1, preliminary round 2 and memorial marks. But after preliminary round, the pre-quarterfinals, the quarterfinals, the semi-finals and the finals as known are all knockout rounds. So then after that we will not be having top 8 teams etc. So from pre-quarterfinals you have knockout. Further, after pre-quarterfinal, from pre-quarterfinal your memorial marks will not be considered at any point of time to calculate the score of your team. So the memorial marks are only and only considered for the preliminary rounds only. Again, to remind you, researchers' test marks are not included in deciding your ranking in the preliminary rounds. Okay, in case of tie in the preliminary round, suppose if 2 or more teams are having the same scores, then we will consider the highest scores of the speakers to break the tie. If still the speakers' scores are also equal, then we will consider, first is memorial. We will consider the memorial marks to break the tie. And if memorial marks are also equal, the second thing that will be considered is the individual speaker mark. Such a situation has not arose and hopefully it will not even arise this year. So I think this much of, yes, this is very important. When you go for argument in your respective court hall, as per your registration form, we have considered you as mooter number 1 and mooter number 2. Sometimes you may have an understanding among yourselves and mooter 2 may go first for arguing and mooter 1 may go later. If you have not brought this to the notice of the judges, they may end up giving mooter 2's marks to mooter 1 and mooter 1's marks to mooter 2. Just now in the inaugural function I have announced that we have 15,000 cash prize and a trophy for best mooter male as well as best mooter female. But if you make this mess among yourself without bringing it to the notice of the judges, you may actually do well, but you may lose your prize because the judges may have changed the marks, given the marks to the other person. So please be careful. Preferably don't change the order. Whatever you have given us the information of mooter 1 and 2, stick to that. But in any extraordinary situation you want to change it, please take note of this, your lordship, and kindly I will be going first and mooter 1 will be going later. Please bring this to the notice of judges so that the right deserving. Yes. And at no point of time you should disclose the identity of your college or speak about your names, because we are trying to take care there should not be anything that creates any bias in the.
The important thing I want to add, whatever she said. Normally what happens after completion of rounds, we will take your marks from the judges. After completion of every session, you will be there only. We will come in front, in your presence only, we will calculate, there only it is over. Judges will be there, court officers will call us, or immediately we will come, we will calculate in your presence and we will disclose marks. Clear? Don't go outside, there only you visit.
Yes, sir, I forgot to tell this. This is the most important thing, and this is why our MKN Moot Court competition has gained a lot of popularity, because we are transparent. The scores are declared in the open court hall, except the final round. So all the preliminary rounds, soon after your presentation is over, please don't leave the court hall. The calculation team will come, calculate the marks in presence of the teams and announce the marks in the open court hall. So you can take a record of how much you got in preliminary 1, preliminary 2, and everything will be known.
So we expect the judges not to leave the hall till calculation is over. Even if they leave, you don't leave the hall. Till results is announced, you don't leave the court hall. We will calculate immediately and declare their own place. Now regarding the drawing of loss, we have 30 teams, 8 court halls. We have 8 court halls, 30 teams. In 8 court halls, in session 2, 7 court halls, 14 teams will compete. And if it PR1, PR2, 2 rounds are there. In PR1, first session, in 8 court halls, 16 teams will compete. Which team right now to come to know? Then, second session, PR1, in 7 court halls, remaining 14 teams will compete. Here, drawing of only for PR1. Why not PR2? Made an explanation. Once we go for drawing of blocks, we will get 15 petitioners, 15 respondents. This is serial number, not code number. Keep in mind, this is serial number. This is serial number. We come to know code number here. Which code number we come to know? So here 30 checks are there. For PR1, only drawing of block. In the check, code for number is there. Session is there. And petitioner or respondent will be there. Code of number, for example, code of number 1, session 1, petition. Then, after drawing, therefore, what we have done? Which code number comes here? Code number should compete with third one here. This versus this one. Suppose here 20 comes. 20 versus 25 in this two. Because here there will be respondents. And for these teams, code one may be same. Code one may be same. Judges may be different. We cannot say that. But teams will be different. You will get not same team, different team. But code one may be same here. And if it comes again, only for PR1, drawing of block is respondent. After drawing of block, we will come to know 15 petitioners, 15 respondents.
This side, side, that's it.
Court hall number team code 1. Court hall number 3.
Court number 3.
Court hall number 3. Session 2. Petition.
Court number 3. Session 2.
Clear? Team 1. Court hall number 3. Session 2. Petition. Up to your session. Team code 2, portal number 1, portal number 1, session 2, respondent.
Next, team 03. Team 03.
Team code number 3, portal number 4, session 2, respondent.
You check there also. Type it.
Report number 4, session 2, respondent.
Team 04.
Portal number 3, session 1, respondent.
Team 05.
Portal number 7, session 1, respondent. Team 6, portal number 4, session 1, petitioner. Team 7, portal number 2, session 2, responding.
Team 8.
Team 8, portal number 6, session 2, petitioner.
Hello.
Team code 18, petitioner memorial. 3 respondent memorial.
Hello. Look here.
Team code 27, petitioner memorial. 28, respondent memorial. 27, 28.
28 respondent.
ಏನಿಲ್ಲ ತೊಗೊಳ್ದಿರಂಗ Excuse me, look here. Okay.
Smiling.
3 petitioner, 23 respondent.
Team code 3, petitioner memorial. 23, respondent memorial.
Okay.
Hello.
Hello. Look here. Okay. Okay.
Portal number 5.
Just to that respective court halls. First one, court hall number 2, Mrs. Pearl Monterio, madam, and Shri Sachidananda Patil, sir. Yes, wonderful. So, court hall number 3, Dr. Murmai M. Vaidya and Shri Dibakar G. Bhatt.
called stem cell therapy, where these stem cell therapies are used to cure serious diseases such as leukemia, cancers, and genetic disorders. Where in Indonesia there are two types of blood banks, that is private core blood banks and hybrid core blood banks. So Lordship, take a note of this, that is Anupam Dheer and his wife had 3 children. When the first child was born, his umbilical cord was released. Later, Your Lordship, when the second child was born, her umbilical cord was restored in the government support hybrid core blood banks. When the third child was born, Your Lordship, hybrid core blood banks refused to take access to the stem cell of the third child, stating that government is following 2-child long policy. Your Lordship, when later in 2022, Anupam Dheer was diagnosed with serious disease of leukemia, where the family approached the private core blood bank, but the private core blood bank refused to give them the access of the stem cells as there were arrears and interest were still payable. Due to financial hardships and the extreme payment, the families couldn't afford core blood banks. But there also they couldn't get the access. Yes, Your Lordship. Because Vivek is a good friend on behalf of the Supreme Court. And the Venegas is appointed and the Supreme Court, right? And he is a good friend. And the court has appointed it.
Yes, the court has appointed to represent petition the legal aid of the
Yes, Your Lordship.
Can it come to jurisdiction?
Yes, Your Lordship. So the present matter arises from suo motu cognizance taken by this Honorable Court of Indonesia under Article 32, read with Article 142 of the Constitution of Indonesia. This Honorable Court is vested in the original jurisdiction to entertain matters involving enforcement and protection of fundamental rights guaranteed under Part 3 of the Constitution. Very much I'll state all the 4 issues.
Which issue you are dealing?
I am dealing with first and second issue, and co-counsel will be dealing with the third and fourth issue. The court, by stem cell therapy, falls within the ambit of essential public health care as constitutional guarantee and right to health. Your Lordship, may please this Honorable Court, the Council on behalf of petitioner most humbly and respectfully submits that umbilical cord, including the stem cell therapy, falls within the ambit of essential public health care. As Article 21 guarantees right, it protects the life, and this Honorable Court has consistently interpreted the term life to Article 47 and Article 21 to ensure the highest available standard of health care. The rich and poor, manageability and development is the obligation of the state to ensure. The state cannot take an argument that once the basic healthcare services are provided, only then that the state can move forward. Because that would put the state to such an extent where it would not be able to justify having any basic healthcare. Further, Your Lordship, the council here would like to argue that the right cannot be reduced to minimum market availability. The right of the state to ensure that there is an availability cannot be reduced to minimum market.
We say that the state is obliged to provide stem cell therapy as a fundamental right.
Much of that, Your Lordship. Your Lordship, the council agrees that the state has stated that the constitution itself quotes that DPSPs are non-binding. However, Your Lordship, the reading of Article 21 in the right to life, in multiple cases like Golda Harris, for Francis Colani, Maneka Pani, all of them have read that the right to life has to be read in line with the DPSPs. Your Lordship, in essence, also the Gujarat Mazdoor Sabha case highlighted that DPSPs are not something that can be binding upon the state. They do lead to a positive obligation that arises in line with the fundamental right. Your Lordship, to answer the question here that the council is posing, it's not merely that the right is not justified. It is that the state has not taken enough effort to ensure that the DPSP aligns with fundamental rights under Article 21 and provide that mechanism. If Your Lordship. Much of that, Your Lordship. Much of that. Your Lordships, the issue to at hand is whether stem cell storage and treatment, including umbilical blood banking, would fall within the ambit of essential public healthcare services under the constitutional guarantee of the right to life. Your Lordship,
Constitution, Your Lordships, as has been held, is a breathing document. In such a way, there is a need for continuous evaluation and expansion of Article 21 to ensure that there are rights to technical economics. But in that particular case, the court had highlighted that the right to digital services also falls under the right to life. Your Lordships, these digital services that the court was claiming were in fact digital services like access to technology. When the court has in its infinite wisdom already propounded that there is an access to technology that must be guaranteed, how can that access be taken away in line with biological resources is the question that the government was addressing. Your Lordships, the chance of survival that increases from 60% to 90% in the case of leukemia that the late Mr. Anupam unfortunately suffered from is a 30% exponential guarantee that is offered by the idea, that is offered by this particular therapy. To take away that 30% right at the name of stating that it is an undesired mode is unwarranted. Your Lordship, to summarize the whole argument, to summarize the whole issue, the Council would like to say the following. Article 21 does not merely stand as an article in the Constitution. It is a sentinel of human dignity, the ark of all of us. Your Lordship's right to life is therefore an expression beyond minimal animal existence and a right to a dignified life. That dignified life cannot be given to a person without the right to justified medical care.
The petitioner first approaches private bank.
Yes, sir.
So, private bank itself is not an instrumentality of state under Article 12. You first convince me on that aspect.
Sure.
How does this public bank will be an instrumentality of the state? That is my first question. Second question would be, upon his failure to enhance the maintenance fee or to comply with the maintenance fees. So that's basically a contractual dispute between him and the private bank. We cannot be dragged into his contractual dispute.
Indeed, Your Lordship. The Council understands and completely acknowledges the dilemma that this court has faced in right to whether or not the private authoritarian right would exist in this case. Your Lordship, the court would like to direct the Council would like to direct the attention to the court on a very small fact. Under the case of Federal Bank, it was held that any particular entity which is performing a sovereign function.
Can be deprived of life except according to procedure established by law, which is just, fair, and not arbitrary. This honorable court has recognized in the case of Maneka Gandhi that the content of this right is shaped by the constitutional principle and not by executive categorization. In the present case, mentioning stem cell storage as not essential does not change the consequence that the survival of a human being was affected by its denial. And such a service that is actually qualified as an essential public healthcare service. If your Lordships will kindly refer to page 4 of the Moot proposition, stem cells were refused to be given to Anupam. Further, as he had saved his life, that took a treatment for which he had submitted his stem cell, he had stored his stem cell, he had also provided a lot of money for that. This, however, brings me to my conclusion that Article 21 can be invoked in this case even if such a therapy would not be treated as an essential healthcare service. If your Lordships do not have any further question under this issue, then I yield the floor to my co-counsel. Much obliged to your Lordships. It was an honor presenting this case in this honorable court.
Lordships, I am the second counsel appearing on behalf of the petitioners. I will be addressing issue 3 and issue 4, and for brevity and clarity, the arguments of the issues have been divided into subsequent limits. For brevity, it has been divided into 2 limits. Your Lordships, first, the demographic restriction unconstitutionally coerces reproductive autonomy and violates the doctrine of unconstitutional conditions. Second, Your Lordships, I will deal with penalizing the third child, how it constitutes arbitrary and wealth-based discrimination under Article 2. Coming to my first point, Your Lordship, we will ask this question. Can the state punish a family for exercising the fundamental right to procreate? I would request your Lordship's attention to para 16, page 13 of Petitioner's Memorial. Page 13 of the para 16. Issues, third issue. Your Lordship, the Supreme Court in Sushita Srivastava had explicitly recognized that the right to procreate is an inseparable facet of personal liberty. Furthermore, in Devika Biswas, it was mandated that a right-based, non-coercive approach should be taken when considering family planning. And also, the state must not utilize the deprivation of vital services such as not providing medical benefits as an instrument for coercing demographic challenges. Moving.
Started at 9:42.
What she is showing is correct, but she is meant for that. So you have to obey what they are doing. So I am telling you that please sum up the first issue.
Your Lordship, the main
Continue with the next.
The first issue is, Lordship, whether umbilical cord stem cell treatment comes under essential treatment.
Yes.
In the Semicide judgment, it has been demonstrated by the Honorable Supreme Court. Umbilical cord stem cell services is a health service. Till now, it is whether Article 21 guaranteeing the right to life and personal liberty can be ignored to claim access to stem cell therapy, even if such treatment is not classified as essential public health care. Article 21's broad scope encompasses emerging technologies vital for survival and dignity, irrespective of essential classification. The state cannot deny access based on resources allocations when lives are at stake. Article 21 of the Constitution has the obligation of the state to preserve life. There can be no second opinion that preservation of human life is of paramount importance. So that means that even if it is not an essential service, when the treatment is for a particular person, it becomes essential. Then also the Article 21 comes into play. Right to health and medical care is a fundamental right. So once it is being declared as a fundamental right under Article 21, the state is obligated to provide those facilities which are of.
As what we can say is fundamental right here.
It has been decided as a health services under state-side system.
That's what you want to say.
My contention is, under the rare disease in Muhammad Amir versus State of Delhi, the Supreme Court has said, for a particular person, if he is in need of treatment, if that treatment saves his life, then it will be an essential under Article 21. Even though for the state it may not be an essential, for an individual, if it is an essential treatment, then Article 21 comes into play.
How you are relating this ICSCR policies to this case?
As India has signed the ICSR policy, it is duty bound to fulfill its international obligation under the said treaty. States are required to adopt and implement a public health strategy and plan of action that reflects the epidemiological burden of disease and not only address major disease burden but also the health concern of the whole population.
How it is concerned to all the facts?
Our facts, Your Lordship, in this case, umbilical cord rules are applicable for a free scheme. Once the government is making a policy of such a nature that so and so scheme will be applicable only to 2 children, then we have to abide by this obligation. It cannot be restricting to a particular population. It has to be the whole population.
Citations also.
My God.
The state is the custodian of all these measures. The state is the custodian of public property, and they are supposed to act in the best interest. So now moving on again, the right to life includes access to healthcare services and essential medical facilities. You can't be saying that this is something that is a cannot be true for you can't be double facing to that well this is correct and that is wrong. That would be absolutely wrong. It says that you need to be extremely fair. You need to be extremely equal.
Preservance, stem cell, is a luxury or essential?
It is an essential.
So when you have the other options to have the life.
My God. Let us look back everywhere. I was in school, of course. We didn't hear of things like Guillain-Barré syndrome. We didn't hear of things like lung cancer, pancreatic cancer. We didn't hear of things of concepts of now what we have with all these hybrid diseases. So we are evolving as a generation. We look at things like Guillain-Barré syndrome where we have people who are they are interacting with their mobile. This disease is going to be less wrong. What we can do, however, is of course, again, borrowing from the environmental law, the precautionary principle and sustainable development. We can predict, we can think about the future from today, considering for all the unknowns that are people. And we are in a transformative constitution of things. We looked at the concept of LGBTQIA+. We have looked at the concepts of now most recently my lord has looked at Aisha case of passive euthanasia. So we are in a very process and reduce structural inequities within society. So our constitution is not one that is separate for the upper class, different for the middle class, and not in existence for the lower class. That is wrong, and that is not what our constitution makers and our authors had in mind when they were working on the constitution. So in conclusion, my lords, I just want to put forth that the concept of whether the imposition of a future law by the state, that is wrong. You cannot be telling anyone. It's okay if you're doing it for elections, that's fantastic. But if you're going to be saying, you have more than 2 kids, you can't get this benefit, especially in regards to health and medical care, that there is a drastic issue. There is a drastic issue. And again, whether judicial intervention is warranted to enforce social and economic rights.
And balance. There is no balance or disparity when insurance policy is discussed. Because I in fact fall in economically vulnerable communities, and these families, when they are curtailed of certain benefits, they cannot go to private healthcare because they cannot afford it. So indirectly, you're depriving them of right to health. This makes it very clear that the state's approach of right to children policy, which mandates the policies and disable them from certain economic and civic welfare, is against the constitutional principles. If the court may permit, I might go for the fourth issue. Yes, Your Lordship.
I think the answer here is when we speak of the policy, we should balance. And if your prayer has been considered and the absolute right of reproduction is affirmed on every individual, state will fail in balancing the available resources, which are very limited. It will be difficult for the state to extend this benefit to every individual, unless and until we have certain limitations for equal distribution of available resources. Right? It affects that balance.
May I take up the answer, Lordship? Well, Lordship, the benefits we are talking right now is directly infringing Article 21. Because reproductive right benefits, which are very much core, state cannot say that we are having financial limitation or resource limitation. Because even though it is progressive realization horizon broadens up through Article 21, and we need to make sure that when these constitutional mandates are endangered, they should.
You mean to say right to reproduction should be protected under Article 21?
Yes, Lord. So we are not asking the state to do a one-time policy system. We're asking them to go face like my co-counsel proved about umbilical cord, or I told about how major pool of states fund is taken by the vulnerable community. For them to sustain their life or livelihood, these funds are very important. And when states cut, and the socio-economic rights won't be properly enforceable. Yes, Your moving on to the fourth issue. The issue is very clear. Whether judicial intervention is warranted to enforce socio-economic rights when administrative or legislative measures fall short of securing right to life and dignity for marginalized community. First, let's understand one thing clearly. Article 21 contains a judicially enforceable constitutional minimum necessary for right to life and dignity. And this is what is a core issue in this case. When life and bodily autonomy are endangered and threatened by financial constraints as stated by the Union of India, this cannot technically be applied as a defense. As there were several cases like Paschim Bengal and Swaraj Abhiyan where
it is respectfully submitted that stem cell storage and umbilical cord blood banking do not fall within the ambit of essential public health care under Article 21. The state has acted within its constitutional validity in mandating access to advanced medical technologies. If with whether
violation of section Article 14, right to equality is violated.
Pardon, my lord, could you repeat?
Now you have stated that there would be, as per the policy, the government has to lay compulsory law, whether it's the right to equality is violated or not.
We as a respondents contend that right to equality is not violated, my lord, because essential public health care is already provided. Like sanitation, immunization, all these essential are provided, my lord.
But poor persons will not get any facility in case of public sector.
The medical technology, no? Making you yourself as a discriminatory treatment to the people at large. Does it amount to violation of Article 14?
Public cord blood banks are already existing, my lord. No reasonable restrictions are there. That I'll be discussing in the next issue, my lord. May I go and I'll deal with the question. Issue 2 deals with whether Article 21 of the Constitution guaranteeing the right to life and personal liberty is not classified as essential public health care. In regarding this, I will be submitting 4 arguments, my lord. It is respectfully submitted that Article 21 of the Constitution of India, though it is expansive in its interpretation, does not confer an absolute right to demand access to all forms of medical care.
I propose to address the court under 3 structured submission, Your Lordship. Constitution of India and separation of powers, enforcement of economic rights under Article. The power of this court to review the conduct of the executive and legislature in relation to fundamental right is not a discretionary action. It is in violation of Article 21. This court is precisely the forum to which they must be able to turn. If Your Lordship could look into petitioner compendium page number 5. Fundamental right of everyone in this country to under Article 21 by this court in Francis Muller case to live with human dignity free from exploitation. The right to live with human dignity is enshrined in Article 21, derives its life breath from the directive principles of state policy and particularly clauses E and F of the Article 39 and Article 41 and 42.
If you are not so in caviling spirit or in a confrontational mode, or with the view to tilt at the executive authority, or seeking to usurp it, but its attempt is to only ensure observance of social and economic rescue programs, legislative as well as executive, framed for the benefit of the heart.
To explain in regard to correct whatever you have read out, that is what I suggested. It is only a corrective, not substantial review. Because legislation and the post of legislation, we cannot directly divide. We have got a limited review system also. Judicial interference insofar as the socio-economic rights are concerned is very restricted.
Yes, Your Lordship. But Council would beg to differ that this problem is mainly based on the fundamental right of the person, Your Lordship. It is affecting the fundamental right.
Come to prayers.
I humbly pray before the Honorable Court that declare the stem cell storage and treatment, including umbilical cord blood banking, form the essential public health care when medically indicated, particularly in case of life-threatening disease. Article 21 of the Constitution guaranteeing the right to life and personal liberty encompass to access advanced, preventive and life-preserving medical treatment, including stem cell therapy, even where such treatment is not presently categorized as essential public health care. Hold that denial of access to stem cell therapy solely on the grounds of classification 3D for healthcare services, benefits and rights insofar as to infringes Article 21. Declare that two-child nor the eligibility criteria for welfare benefits is imposed by the government is unconstitutional, being violative of Article 14 and 21 of the Constitution. Declare the establishment and strengthening of regulated public cord blood.
Application to other state benefits including subsidized housing schemes, government employment benefits, educational scholarships, panchayat election eligibility, etc. The policy applies uniformly to all citizens seeking access to public funded benefits. It does not discriminate against any particular class or community. The Theer and family were much aware of this policy when they chose to have a third child. Your Lordship, the state cannot be faulted for consistently applying its policies. The child is not punished. Your Lordship, third point I am going to present in front of the
So you can't build a building in the air. Needs a foundation. Keep that.
ಪ್ರಶಾಂತ್ ಪದಾನ್ಲಿ ರಾತ್ರಿ ಹೌದಾ ಬರ್ತೀನಿ ಹೇಳ್ತಂದ್ರಪ್ಪ ಇಲ್ಲ ನೀನು ರಾತ್ರಿ ಫೋನ್ ಮಾಡಿದ್ದೆ
Greetings, Doctor. The Council seeks permission to move forward. Honorable Court, this Council appear in behalf of the petitioners in the case of interference, citizens' equitable access to advanced healthcare technologies case, Your Lordship. Your Lordship, for the perusal of the bench, the Council would like to submit compendiums. Like to submit 2 compendiums for both the judges and 1 for the opposite houses. state the brief pedestal of the facts, Your Lordship. Much obliged, Your Lordship. Your Lordship, this happens in the Union of Indoria, where constitutional rights are considered extremely important, Your Lordship, especially when it comes to Article 21, which has been expanded and given recognition, especially for right to health. Your Lordship, here with the advancement of technology, there comes a new technology where preservation of umbilical cord blood cells are taken into place, Your Lordship, and this advancement has proved to have multiple benefits, Your Lordship, where it is proved to cure cancer and multiple genetic.
That these things are cured by using this technology.
Your Lordship, in the Moot proposition itself, it has clearly stated that
Any data is there. These many patients were treated with this technology, these were treated like this, and they are successfully cured like this.
Your Lordship, the success rate of this curing a particular disease has drastically increased, Your Lordship, and that is well stated in page number 2, paragraph. In this particular case, this is seen to be an advancement in the medical era, and for the there is an annual fees of 1 lakh every year, Your Lordship. And for the hybrid method, where 40% of what the amount is collected in the private sector is much obliged, Your Lordship.
Come to the points.
Much obliged, Your Lordship. The council is like
Which issue are we would like to canvass?
Your Lordship, the council will be dealing with issues 1 and 2, and my opposite council had also drafted a first issue, which will also be dealt by the current council, Your Lordship. Much obliged, Your Lordship.
Which issue drafted?
Your Lordship, the opponent has drafted an extra issue which spoke about the social economical aspect of the umbilical cord, Your Lordship.
Must come to the point number 1.
Much obliged, Your Lordship. Your Lordship, the first issue deals with whether the umbilical cord should public health care, Your Lordship. Your Lordship, in this particular issue, Your Lordship, the council humbly submits that though the terminology that it does come under essential public health care. Your Lordship, now the terminology of essential public health care, Your Lordship, it is not clearly defined in any judgment or in any legislation, Your Lordship. Your Lordship, now to break down this into 3 parts, Your Lordship. First,
Council, first tell me how it comes under essential public health.
much obliged, Your Lordship. Your Lordship, the council will be elaborating of what essential public health care is and obligation and duties to bound to do. Even though DPSP couldn't be legally enforced in the court, it doesn't mean the state doesn't have the obligation. The state should follow the DPSP. The state still has the duty and responsibility to implement them.
Okay, let me ask you one thing.
Hey.
See, these are all very expensive technologies, right? You yourself have quoted that. These are how do you propose to overcome the fiscal deficit that will be put on the government by subsidizing these innovative, modern and very expensive technologies? See, these are all very expensive technologies. And these are very innovative, lots of research is going on into these new technologies. Government should subsidize these and it should provide to every citizen, right? So how do you propose to overcome the fiscal deficit that will be created on the public exchequer? See, government constitution is not, but how do you justify that very expensive medical treatments that needs to be provided free of cost for
who has to get the expenditure?
Indeed, your option is the luxury treatment. It is said to be luxury treatment, but it is incorrect because, for example, if the child is born with leukemia, the only cure is this stem cell therapy. So, if the cure is denied, it is indirectly.
I agree with the importance of saying this thing in the distant future. So, but how do you propose to overcome the financial burden that will be put on the government?
Do you suggest any schemes for granting subsidies for providing care to or state should give some subsidy to the medical treatment also?
It is still saving
responsibility to provide the medical service is not static, but it is not said to be an essential, but it involves what is the evolutionary characteristics of healthcare obligation, that by the improvement of healthcare, by having an evolved technology right now in the medical field, by having any evolutionary character in the healthcare can only help to have
See, let me make it more clear. India is already overburdened by the subsidies, existing subsidies. We are one of the highest tax-paying nations in the world. Our citizens are one of the highest tax-paying citizens in the world. So by suggesting that these expensive treatments, they need to be subsidized by the government, so it will create further burden on the taxpayer. So how is it justified?
So, it has been mentioned in the previous days when it comes to this stem cell therapy. In the MKN stem cell India therapeutic private limited versus Commission of Central Exercises Tax. So the fact of the case is,
entire issue 4 categorically in the favor of the petitioners. It states that it must be acknowledged that from the onset of pandemic efforts were taken, this court at the beginning took suo motu cognizance of the situation distribution of essential supplies, which led to the development of a national cell. This court had directed the National Disaster Management Authority to frame appropriate guidelines, which is of paramount importance. Now, last line, in the executive domain, the absence of any structured framework of relief in the exceptional circumstances affecting life and dignity may want response. This is what the petitioners seek for, a limited institutional response whereby the respondents are directed to frame a proper policy whereby the umbilical cord blood technology is received by everyone. Para 33 says, that said, this court has time and again also reiterated that executive which has been democratically elected by the people is vested with competence. But at the same time, this constitutionally protected separation of powers cannot in any scenario come in the way of the judiciary when the fundamental rights of the citizens are violated. Due to when policies exist, even when policies do not exist, which are affecting the rights of a person under Article 21, this court necessarily has the power and this court necessarily invokes the jurisdiction conferred in it by the Constitution under 32 to give directions to the state so as to do complete justice and to protect the fundamental rights. Stated that the PUC judgment, that is the right to food judgment, is not it. The court definitely intervenes. This court intervenes, issues a continuing mandamus. Similarly, even in this matter, if this court issues a continuing mandamus or any other form like establishing a committee, the respondent has stated the committee should be of the parliamentary committee. I would like to completely disagree. The committee established by this court to ascertain the merits of the particular therapy, if this court wants, can do so. However, that is the case for the petitioner insofar as the therapy is concerned. My learned co-speaker will take the issue number 2.
You in your prayer, you have prayed that to declare UCPT as an essential public health.
Yes, sir.
It is purely in the ambit of legislation for the declaring and scheduling decision of the government.
The policy decision, the government has not categorically framed any policy decision as such. And considering the nature of this particular technology, that is our submission that it should be made an essential. This particular technology is essential to the Article 21 rights of the general citizen.
But Article 21 is too vague. There is no classification in Article 21.
Judges of Vasamukha.
Articulated the concept of transformative constitutionalism, which explicitly mentioned
that the scope of dignity, liberty, equality and bodily integrity should increase with contemporary knowledge. Now drawing to the factual matrix, the idea of constitutional transformative constitute in time based on the constitutional conditions that were present when the constitution came into effect itself. It should change. The constitution should also evolve in order to incorporate the same. Stem cell therapy is one such example. Now, because right to health includes the established that life-saving treatment falls within the ambit stem cell therapy falls within the ambit of life-saving treatment. Thus, it is humbly contended that even if stem cell therapy is not essential, Article 21 shall be violated if the access of stem cell therapy is not given to the society.
Judgment about the bone marrow therapy.
Yes.
The concept that was brought forward over there was, if bone marrow can be utilized in a larger sense, it has to be utilized among the public, whoever is in requirement of it, with the present scenario itself.
Yes.
And that is how we'll give them 2 rules. And that is how private blood banks and there are public blood banks. They give you a receipt, and if you get your own blood, it is fine. If you don't, you get somebody else's blood. But the same method is used if you are able to store your own blood and get your own blood back after a certain age. It actually rejuvenates your health and your body at the same time. And this has been proven. So when blood is not a matrix and you are not asking about anything else, any other health condition, why are you very bent upon using this only facility when it is so much costlier than other metrics which would have been asked by yourself?
Completely understand and thank you for the question, Doctor. The matter at hand where we are drawing parallels between blood that is stored and umbilical blood cord cells that are stored. Again, like already stated, umbilical blood cord cell therapy and the positive or the advantages and the benefits that the society receives and what people get from, let's say, making any other treatment an essential healthcare service. Now, we should also see the parity in the life expectancy.
So once if you have, you check everything.
No.
Once the announce is done.
No, we have already cross-checked, 2 times we cross-checked.
They ask them to send, no?